I want to welcome the bill at the outset and thank Ministers Brown and McEntee for bringing it forward. I also want to thank the members of my Justice Committee, two of whom, Deputy Kenny, Deputy Cathal McNeill, are present for the debate, and others have been in and out. I just thank them for their work on this bill, because this, I think, is one of the first bills as regards the committee's structure. Shortly after the committee was established, this bill came through pre-legislative scrutiny. I think it might have been the first bill to do so, and we're now seeing it coming through second stage. And I do note that a number of the recommendations which we made at pre-legislative scrutiny have made it into the bill. So it's a good example of, I suppose, good collegiate constructive work across the Houses through the committee system. So as Chair of the committee, I want to just thank the members for that, and their very constructive and helpful inputs throughout. The bill, I think, is very welcome, as I've said. I think the bill, as Deputy Callahan, I think Deputy Cathal McNeill mentioned earlier, has taken probably the best of both in terms of previous bills, whilst actually removing some of the more problematic aspects. There were attempts in the House in the last term. Minister Ross was particularly culpable, shall we say, despite not being the Minister for Justice, at driving certain views, shall we say. And some of those issues have been, I think, addressed in this bill, and some of them even have been removed where appropriate. But actually, it takes the good out of that, and indeed Deputy Callahan's own effort forward into this new composite bill, and that's very much to be welcomed. It's not a panacea. There is still much to do. A lot more to do, as a famous previous occupant of this House indeed said, which is true of many things. But it is certainly progress, and I welcome it, and I think it is very important that we move forward. One of the things that struck me at the outset of this consideration, to my great surprise, I had always imagined JAB, the Judicial Appointments Advisory Board, to be a sort of selection process or assessment process, and I had understood that they would make recommendations and prioritise and present, I suppose, a slate from which people could choose, or the government could choose, and was surprised to find that really it served as largely a form of clearinghouse, akin to no more than a guard of vetting, that somebody was eligible for a role as opposed to being suitable, or being particularly suitable or particularly useful, and there didn't seem to be any kind of ranking or assessment, which I thought was a pity. And I understand the freedom of government, I suppose the power to appoint judges has always been constitutionally guaranteed, but I think that's been addressed in this bill in terms of the, I think, far more, shall I say, rigorous, more useful and practical process to actually begin to shortlist and make a number of recommendations. And I think that the government would then choose from those recommendations, as opposed to having a process and procedure and then going around the House and ignoring it and picking somebody off the bat, which previously was an issue. And we know it happened, and it happened many times in many jurisdictions, and perhaps many of those appointed actually worked out very well in the end. But I think that a process to screen candidates, shortlist and present for appointment in a priority or in a sort of assessed manner makes far more sense, and I think is very much to be welcomed. I mentioned that the Minister has taken on some of the appointments, some of the recommendations from the committee. In one in particular, I think Head 6, or appointment recommendation 6, the committee made, talked about the definitions of experience required for academic selection, and the concept of appointing academic practitioners or academic personnel to the bench is not new. It's done in certain jurisdictions. We have some very eminent jurists and legal scholars on the bench in Ireland, indeed, and we benefit from their expertise. But what they have in common is they actually have practical experience as well. I think that's so important, and particularly, and something perhaps that isn't always understood fully, our appellate courts have a panel, and they have a division, they have a number of judges sitting in parallel together, and they're considering an appeal on a point of law, and it's very technical and very detailed and very scientific or very academic. But the majority of decisions, certainly the first instance courts, which includes the High Court, Circuit District and all others below the Court of Appeal, which is the vast majority of cases that come through, are far more practical and all about, I suppose, inquisitions into fact-finding, and also, on any morning of the week, managing a list and actually managing quite an unruly room at times, and trying to put some kind of structure on a number of cases which are being put before it, and trying to second-guess the room and trying to read the room and trying to decide whether some ex-parte application jumps priority over some motion that's been filed 2 weeks previously, whether some other matter may be urgent, whether the matter needs to be heard, whether a witness can give evidence, whether it's an affidavit or only, and all of these practical considerations to manage a courtroom. And we suggest at committee stage that for an academic practitioner to come in, actually an academic non-practitioner, who might have a very fine, thorough knowledge of the law at an academic level, but who's never stepped foot in a courtroom in their life, wouldn't actually be very practical. I wouldn't actually lead to good management of that courtroom. And it's akin, a point I made at committee stage, to taking a very eminent medical scholar who would never practice medicine and pointing them as the head of a busy accident and emergency department on a Saturday night. where that actually be the person with the least experience became the most senior person in the room, and I just think it wouldn't have good results. And I say we made the same point in this. Certainly academics are very welcome and will enhance the bench, but the requirement, and has now been incorporated, that they have a minimum of 3 years experience. 3 years is actually quite low, but that some degree of practical experience have been present before coming in, I think is very welcome, and I thank the ministers for taking that point on board. Another point, I think I want to, before we leave this debate, or during the course of this debate, we do need to look at our per capita judiciary in terms of the numbers we have to serve us. And we are quite low compared to Europe and internationally. And it's a thing that has come out in a number of inquiries on the committee that on many unexpected topics, a point made from various witnesses and stakeholders have been we need more judges. We need more people to hear cases and hold cases and hold proceedings and pass judgment, because many matters, be it from a victim who was waiting time and time again to come back in and seeing matters delayed and being re-traumatised every time they have to appear in the court, through a complex area of law that needs to be clarified for the benefit sometimes of this House and of other stakeholders and of a particular sector, to logjams in employment courts and all across the board. So it is really important that we address that. And I would say to Minister Brown, who's here today, and to Minister McAtee, I've made it before, we need to do that. The government is doing that. The government have made a number of appointments in recent over the last year, but we need to get that up. We need I suppose, an injection to get us up to the level that will be seen across comparable jurisdictions. The last point I'll make, and I'll yield my time after this, it's not in the bill as such, but I think the Judicial Council is considering the issue of judicial conduct. And when I say that, I'm talking about, there's a lot of talk these days about safe spaces and about dignity at work. Sometimes, particularly, dare I say, in the lower courts, one can be a king or queen of one's own castle. And I'd say dignity isn't always afforded to those practising or appearing, or witnesses or Gardaí or officials. And that's something I think the Judicial Council are looking at, I suppose, a sort of a disciplinary form or an internal complaints procedure. I think it's something that's needed. We have it in every other walk of life. And somebody, because they're sent to the bench, should not be immune from being asked to be, I suppose, accountable in that regard as well. Thank you, Cathaoirleach.